reserve 5 minutes for rebuttal, if I may, please.
You may.
Your Honor, I'm Blaine Winship from the Office of the Attorney General here on behalf of Christina Daly, sued in her official capacity as Secretary of the State of Florida Department of Juvenile Justice. We are appealing from a judgment of the Circuit Court that we believe was fundamentally in error. We have in our initial and reply briefs both, I think, fairly conclusively shown that neither of the sources of funds that are relied upon by the appellees to satisfy the judgment below, there's a trust fund in here, and there's also funds that are appropriated to DJJ itself. Neither of those is available as a remedy to be able to pay any judgment, and as a consequence, the court lacks jurisdiction here.
So your argument is then that even if you had $100 million in surplus in the agency's budget, I think your argument has to be there still can be no remedy, right?
Well, that's an interesting hypothetical. I mean, if you have that kind of money, if it's appropriated, the question would be, what's it been appropriated for? Because the control over the appropriations as a matter of well-settled constitutional law rests with the legislature. They get to define the terms upon which the public money is spent. And so we'd have to look and see what we have for an appropriation, and whether that appropriation would extend to paying past amounts from past fiscal years or not. In this case, we don't have anything of the sort. And that's the problem that the...
Well, the trial judge ordered it to be paid out of the detention trust fund, right?
The trial judge, basically found that there were two different places where you could get it, and neither of those actually stands up on further analysis. We have two different statutes that are at stake here. I'll just go directly to the statutes. We don't have a lot of time, but I just want to note that the problem with those statutes ultimately is a constitutional problem, and we've cited 3 different constitutional provisions that completely obliterate a claim that this court has jurisdiction to award relief. The first one being the constitutional provision with regard to control over appropriations that we just discussed. The second being the separation of powers, and the third being sovereign immunity. We briefed all of those, and I'll be happy to come back to them anytime any of you wishes. The 2 different statutes that we have at issue here are sections 215.26 and 985.686. The problem in both cases is that neither one of them leads to where the appellees want to go. 215.26 is the general tax refund statute. It says, basically, if you're going to get a refund, you have to go to the appropriation in which the tax was erroneously paid into in the first place. But in this case, what it was paid into was a trust fund. And we maintain, under the basic principle, well-settled principle, that the specific controls over the general, that when you look at Chapter 215, you look at the trust fund statute, 215.32, and that controls. And that statute is very specific in saying you can't give money back out of a trust fund unless there's money there.
Isn't there money there?
No, there isn't to be given back. That's the key question.
But you're not saying there isn't money there. You're just saying you don't believe it's money that should be given back. Isn't there well in excess of the amount necessary to make these repayments?
Oh, there is, Your Honor, but that money doesn't belong to DJJ, and it can't use it for this purpose. That money's been paid in by other counties. It's their property. If we were to, and by the way, that trust fund exists for the purpose of funding current needs for juvenile detention cost funding. If money is taken out of that trust fund, it will necessarily leave a financial hole in there, and there's no way for that to make it up, because it's the participating county's money that is in that trust fund. Well, except, of course, for fiscally constrained counties, which get money put in, but this is earmarked to be put in on behalf of those particular counties.
Doesn't your whole argument really rely on the fact that there are sub-accounts for each of these counties?
It doesn't, in a sense, the strict sense of there being strict sub-accounts. We've had a lot of disputes about that, as you know, and you've seen this in the briefing. I was the one, I confess, I was the one who initially likened this to a sub-account situation, because I do a lot of charitable trust work for the Attorney General, and we see pooled trust accounts. And that's the same sort of circumstance we have. The difference here is that We need an annual reconciliation because during the course of the year, it's just not possible on any given day with the sharing of costs and all, and having to figure out which costs get allocated to which county and which get allocated
Well,
to
maybe
DJJ.
we can try
You
it this
can't-
way.
I'm sorry, Your Honor.
The trial judge said you had 15 million in excess or available for repayment. Is that correct?
I believe he said that, but he was incorrect in saying that.
So
It's
your
not
argument,
available.
you've got two arguments then, I guess. One is, A, constitutionally, if we had $100 million surplus in that trust fund, we don't have to pay you, and you can't require us to pay you, right? That's your main argument, is that there's no authority for this court or any court to order you to make that payment regardless of the amount of funding available.
If, as I had said earlier, yes, Your Honor, if the appropriation itself doesn't allow for that, if the appropriation itself allows for that, and the agency is simply refusing to follow the appropriation law that was established by the legislature, and simply for some reason, God only knows what, refusing to make a payment, well, that might be a different issue.
What's the exact language of the trust fund statute that would prohibit payment?
Well, the trust fund statute says that the trust fund money is to be used only for the payment of juvenile detention costs. And that's the problem with the trust fund. And well, there are two problems. One is the
Isn't that
limitation.
what these costs are?
Pardon me?
Isn't that what these costs are, juvenile detention costs?
That's right. But the question is whose money to pay which costs? And that's the problem we have here. There is no money as of now in this trust fund that is available to be diverted away from its statutory limited purposes on behalf of those counties that have paid that money in and participated to
So
go
your
and pay
argument
these
is
judgments.
basically that this is a trust fund devoted solely to detention, juvenile detention. The counties have to pay 50% unless they're constrained. And it's sort of an ongoing concern where they pay quarterly or monthly or however. And we don't have surplus money to rebate this overpayment that the two counties made, right?
Correct, Your Honor.
And so the money's not there.
Correct.
So it's not, your argument's not that if the money were there, we still don't have to pay you.
Well, as I said,
Or is it both?
The problem is what's confusing is they're talking about two different sources of appropriation. The way this process worked was DJJ would fund its own half of this from monies that it got from the legislature, given for its appropriation for juvenile detention costs for that fiscal year.
And that's general revenue, right?
It came out of different sources, yes, ultimately general revenue. But at the end of the year, the fiscal years, that money would revert if it hadn't been paid. DJJ made a mistake, and it should have been paying out of appropriations, but it should have been seeking greater appropriations because it was using a wrong formula. And pursuant to its formula, it would then go and ask for money from the state. We're going back several years now. It would go and ask for money from the state to fund its share of juvenile detention costs. The county's shares were a separate basket. They came into this trust fund. This is the fund that Section 215.26 would direct us to look at exclusively for repaying monies that were incorrectly paid in. This is what the plaintiff, the appellees are relying on.
Well, you're saying isn't entirely making sense because they put the excess money in, they're just asking it to be paid back.
The excess money that they put in was used to pay detention costs. The costs were paid. The monies were emptied out of the account. Where one of these appellees actually, when they exited the program, where they had some money left in the account, we deemed that to be a trust termination and gave them the amount of that refund. But that's only because that money was determined actually still to be there. It hadn't been used to pay for detention costs. But all of the other monies were actually used to pay the costs. These monies that come in go out to outside services, outside contract vendors and such. They're used to pay for the juvenile detention care services. That's where these monies go. These monies are not there
So
anymore.
the $8 million, as my colleague mentioned, the $8 million overpayment that the two counties made, that went to other counties' responsibilities, or it went to other uses by DJJ? Where's the $8 million?
The $8 million was spent by DJJ.
On what?
Detention services that DJJ should have been paying for itself out of a separate appropriation.
Okay, so that's
DJJ
DJJ supplemented their own budget with the $8 million overpayment. Nobody disputes the amount.
No, that's not true, Your Honor. DJJ didn't have that money to supplement. DJJ had asked for too little money from the legislature in the first place because it made a mistake in how it calculated what it was supposed to be paying in. And it was ultimately later determined that they had made that kind of an error. But there's no money left. And if DJJ had theoretically had any money left over, it would have reverted at the end of the fiscal year.
Well,
there is no longer any
why
money.
not pay the $8 million and ask for a budget amendment from the Legislative Budget Commission?
Well, there isn't anything there that obligates DJJ to do that. And in fact, the legislature...
Well, I mean, there's a court order obligating you to do it.
Well,
so you could then ask the legislature to approve an $8 million budget amendment.
The courts do not have the authority to order an agency to go and do that kind of thing. That is strictly off limits, and I don't think that's actually a matter of dispute. If it is, I don't know how it can be with the cases that we've cited to Your Honor. With regard to the limitations of the judiciary, you can't command an agency to go and juggle its books or go to the legislature. And in this case, and I see I'm into my time, but for rebuttal, but the legislature itself has already acted separately to give a remedy to the counties if they choose to partake of it. This is basically inconsistent with the notion that there is a remedy already available at law for the counties. All of the other counties that were having disputes with the Department of Juvenile Justice, they have all basically accepted the legislature's overture, and they have dropped their litigation. We only have these two outliers that remain that have refused to partake of that. But there isn't any appropriation, and the court simply doesn't have the authority to order DJJ to go out and somehow shake the trees to try to find this money.
May it please the court. My name is Greg Stewart of the law firm of Neighbors, Giblin, Nickerson, representing Polk County and Seminole County. This is the fifth time that this matter has been brought before this court.
It's the last one, I hope.
I hope so too, Your Honor. The circumstances of Polk and Seminole County are unique. They have left the system, which was authorized under the statute, and they are providing juvenile detention locally. They no longer make contributions. They're no longer subject to the reconciliation. But these $8 million, those amounts of money were overpayments that they made based upon the Department of Juvenile Justice misusing the formula. Now, where we are, and there are two separate statutory requirements that we are seeking enforcement of. The first is, as Mr. Winship has indicated, 21526. That is the general provision that any time there has been an overpayment, whether lawful or unlawful, mistake or not, that is the remedy that parties can go and seek a refund of that amount from the state treasury. Second is 985-686, which is the juvenile justice statute. Now, Mr. Winship indicated that Polk and Seminole are somehow the outliers. They have no remedy within the system because they're not a part of it anymore. The legislature gave them that option, and they have exercised that, and they're providing that on their own. Now, it is important to recognize what we have in fact established in these four other decisions by this court. The first is that, in fact, Department of Juvenile Justice misapplied the formula for the allocation of county costs versus state costs.
I don't think you need to visit the history of this litigation. If you want to,
well,
you're free to do so and use your time accordingly. But the issue we have before us is nobody's disputing you overpaid. The Attorney General is not disputing that. Nobody's disputing that it was, a mistake. We heard him say it himself, opposing counsel. The argument, basically, from the state of Florida is you don't have a remedy, period. You cannot get the money from the Department of Juvenile Justice. So maybe you should, just a helpful suggestion, address that issue.
Well, I will, Your Honor, and
Nobody's disputing our 4 cases and the mathematics involved. The Department of Juvenile Justice owes your clients $8 million.
Well, and I do think that it is important to note for this court, I'm sure you're aware of it, but one of the crucial matters that this court previously determined is that the department took that overpayment and paid what their responsibility should have been.
He just said that.
And
He just said he took your $8 million, the department took your $8 million, and because they didn't get $8 million that they needed from the legislature, they used your money.
And in terms of correcting a little bit what Mr. Winship said, the trial court did not order the department to pay out of a particular fund. What it did order is that these are funds that they are contending they cannot use. And the trial court looked at each of those and found that they were available remedies if, in fact, they were going to do that. However, they have chose not to do that. There are a variety of remedies that are available that they could have done. And in the Marion County DJJ case, this court indicated that they are under an affirmative obligation to provide a meaningful reconciliation. Since that decision has been done, they have done nothing. They didn't seek an appropriation. They didn't seek to use their surplus general funds. They didn't seek a budgetary transfer. Rather, they come to this court and say, we don't have to do any of that, and therefore the counties are out of luck.
Counsel, let's say we have just a regular tort case against CJJ, and there's a judgment entered against them, and it's above the sovereign immunity limits, so they don't have the authority to pay the money to you. Who has the obligation in that case to seek an appropriation from the legislature to cover the remainder?
Well, in a tort case, the general claims bill process would normally be sponsored. It would have to be introduced by a member of the legislature. But the individual, normally how that occurs is that the plaintiff or the injured party would seek a sponsorship by a member of the legislature. Ultimately, the legislature and what is introduced in the legislature must be sponsored by a member of the legislature.
So I think my next obvious question is, why does the department have the obligation to secure this money from the legislature instead of the counties?
2 reasons. First, let's look at 21526, which is the tax refund statute. That particular statute has specific appropriation language in it that any funds required to be refunded are deemed to be appropriated and paid from that fund. Now, the argument that the Attorney General is making is that you only look at the trust fund. We would submit that the analysis of the trial court is correct, that not only could that be used as the source of funds, but you could also use their general fund appropriation, because it is because they used those counties' monies that it did not require them to make that payment from the general fund. So they basically got the benefit of the county's money to offset what they would normally have to fund from the general fund. So either of those funds would be available under 21526. Now, looking at 985-686, the other statutory provision, that particular provision, and as held by this court, the obligation to seek the appropriation, to make that reconciliation, to make sure that Polk and Seminole County do not, in fact, pay more than their actual costs, this court held that it was their obligation, not the county's, to have to go forward. And they struck various footnotes that the department kept putting in their final orders that would basically say, it's not our problem, counties, you have to solve the problem that they created. This court rejected that argument, and it said that they had the obligation to make the meaningful reconciliation. Now, and it is important on the general fund that these and on the trust fund that these arguments have been raised to avoid payment. But if you look at the practice of the department, they're inconsistent with these arguments. First of all, we are in this litigation simply because they raided the trust fund and used it to pay their fair share. Secondly, they have paid refunds in the past to both Polk and Seminole County and to other counties. And on all of those circumstances, the process that was used was 215-26. They paid it out of the trust fund, and they did not seek an appropriation or require an appropriation. And now they come and say, well, we couldn't do that, even though they have a pattern and practice of doing exactly that.
Seems the key is really, or one of the keys is certainly whether or not this statute would allow for the recoupment of money, 215-26.
Well, clearly,
the state's arguing, obviously, that they're not. I think that any arguments you can make to clarify that would be helpful.
Surely. 215-26 is specifically for that purpose, and it applies to any monies wrongfully paid into the treasury of the state, and that is irregardless if it's paid into a trust fund or any other fund that's created for the management of the money. But it applies to any payment, and it talks in terms of overpayments specifically. It doesn't require any kind of willful intent or wrongful intent. If there's any kind of overpayment, that statute is the one that's available, and it does in fact apply to governmental entities. Governmental entity has been found to be a person under that statute. Now, what we're dealing with here is that notwithstanding the fact that we have followed the procedures, we have filed the application as required, it was rejected. It was rejected on the basis that they didn't think it should be applied to governmental entities. Nowhere in the rejection of the application did they indicate that lack of money or unavailability of money was the reason. And the statute itself requires the department to set forth the reason why they are denying the reimbursement. So when you're looking at 215-26, that statute is in fact a reimbursement or refund statute. That is the only remedy that is available under that statute. 985-686, the issue there is that they have the obligation to reconcile it. They can no longer give credits because credits are no longer a viable alternative since Polk and Seminole are not part of the system. But that is, this court in the Marion County decision made it crystal clear that that is their obligation. And in fact, it was pretty much conceded at the trial court the only viable remedy is in fact a refund. Nevertheless, they have failed to take any action to address that. And I would submit that the general fund is an available remedy. They have general fund allocation that goes just for secure detention. They have a general fund allocation that applies to their department funding as a whole, and each of those funds could be used. There's mechanisms in place. They just can't sit there and cross their arms on their chest and say, I'm not going to do it. They have ability to resolve this issue that can be used. They have simply elected not to do it.
What specifically are you asking the court to do?
What we are doing under the 215-26, since refund is the only remedy that is available, we would ask that the court find that the counties have filed their applications, that the applications are well taken, and that they order the refund under that statute. We aren't asking you to direct the legislature to do anything. What we are doing is we're asking that the legislature has acted. They've set forth the process which we've complied with, and you to order the department to comply with that statutory authority. The same on Section 985-686. Here we have a process where the department is required to create accounts for the deposit of county funding. That funding is then deposited there, and it is to be used for their actual cost. At the end of the year, the statute requires a meaningful reconciliation. We are asking that they provide that reconciliation to make whole so that both Polk and Seminole County paid no more than their actual cost. And we know the differential is 4.7 approximately for Polk and a little over $4 million for Seminole. So there's no dispute in the amount. But all we are saying is that department should enforce the requirements as set forth by the legislature.
Your argument is you're no different than a party to a breach of contract action against the department, right? Your argument is if you sold, 10,000 computers to the Department of Juvenile Justice and they said, we just won't pay, this same statute would authorize the relief you seek here.
No, sir, I don't believe it would, because where the 21526 is involved is where there has been a payment, a forced payment into the state treasuries. And the state treasury, there's an overpayment. I paid too much. And so I'm seeking a refund. This is not an arm-length transaction.
And your argument is that's not limited to a taxpayer?
That is not limited to a taxpayer.
And your argument is a county is a person?
County is a person under the definition of 1.01 Florida statutes, which sets forth the definitions. And person defines and has been held in the, I think it's the Lemons case that we cited in our brief, both at the, I think it was the 4th District and Supreme Court. It was reversed on other grounds at the Supreme Court level, but that was the rationale. And we believe that that 21526 clearly applies to a governmental entity and others. But at this point in time, and we are not asking for you to direct the legislature to take any action. What we are asking is that the legislature has already acted. It is put on the books.
You are asking for an opinion saying that the judiciary orders the executive branch to pay $8.7 million to your two clients.
We are saying under Section 21526, because the legislature has already directed, that is the remedy if in fact they qualify. And the trial court has found that they qualify, and as such, there's no discretion. At that point, once we meet those criteria, we are to be reimbursed. As to 985, 686.
Well, the statute doesn't talk about reimbursement. 21526 does, but not the reconciliation statute.
No, I agree. And I
And
think
their argument is that's more specific than Chapter 215, therefore it controls.
I would disagree. We have two separate processes where the legislature is, and I would suggest that they are probably alternatives because the remedy is the same under both. But we proved our case that we had a right to proceed under both statutes. And whether it's 21526 or whether it's 985, 686, where they provide the meaningful reconciliation, we are entitled to our relief at that time. And my time is up. I would ask that this court affirm the trial court order entered in this case. Thank you.
Madam Clerk, we'll give the appellant an additional 30 seconds.
Thank you, Your Honor. I appreciate it. I'll need it. I just wanted to note, first of all, let's be clear about this. Appalese, the counties, did not pay money into the General Revenue Fund. They paid money into the trust fund. They paid it into the trust fund. Trust funds are controlled by Section 215.32. They never want to talk about Section 215.32 because it doesn't help them any. But the problem they have is that...
Why does 21526 not control?
Well, 215.26, it would ordinarily control, but it talks about getting money back from the same fund that you paid into. And it talks about the idea that, generally speaking, there will be excess appropriations put into those so that there'll be money there.
Well, I think that statute essentially says when someone has overpaid the state, you can tell me where I'm reading this wrongly, where the person, assuming they are a person, where the person overpays the state, by operation of law, there is an appropriation deemed authorized by the legislature to repay the overpayment.
But they're not...
I don't recall that statute saying it has to be from a specific fund.
The statute doesn't, but the statute is designed with regard to paying money to the state. This money wasn't paid to the state. This money was paid into a trust fund. It was administered
Now, you're not
by
arguing
the
that
state.
the 8.7 didn't go to the state, are you?
Correct. It went to a trust fund. The
But
money was
trust
held
fund-
in the general
The
revenue.
trust fund was the juvenile detention, secure detention funding mechanism to provide what eventually was determined to be post-adjudicatory juvenile detention. That was a state agency using that money. You yourself said in your initial argument that, well, we use that money to cover general revenue shortfalls.
We use that money to pay costs to
Right.
third parties.
But you're a state agency.
Well, that's right. We were the state agency that was administering the trust. So we administered the trust. We made a mistake in administering the trust. We paid other people's money from a trust fund to outsiders for juvenile detention care that should have been paid by DJJ. DJJ made a mistake. But
You
the
might wanna
problem is,
just speaking for myself, you might want to focus on why 215.26 can't be interpreted in this fashion without violating Article 2, Section 3.
well, it can't, Your Honor, because it would amount to taking money without a proper, this is not an appropriation to allow the trust fund to be raided and take other counties' money out of there. All that's left, I can't emphasize this enough to you, all that's left in the trust fund is money that belongs to other counties that
So
have
this
paid
is
it in. Robbing
Septem-
Peter to pay Paul.
This is September. The fiscal year doesn't end until next July 1. So is it your argument or your declaration to the court that trust fund has no general revenue from DJJ, has only monies put in by other counties?
Absolutely, absolutely right,
So
Your
that
Honor.
cannot be a source for the repayment.
Correct. And
So
if you
why
look
not
at,
general revenue from the department's budget?
pardon me?
Why not general revenue from the department's budget?
Because the department doesn't have an appropriation to tap
Then
into
that was
general
my
revenue.
earlier question. Why not seek a budget amendment from the Legislative Budget Commission?
Because that's not something that is within the court's power to order. That's not
We
the
wouldn't do it. We would order you to make the payment, and you would seek the budget amendment from the LBC.
But you don't have the jurisdiction to do that, and that's our point, Your Honor. And I would just note, if you look at if you look at section 11.066 of the Florida statutes, where with regard to suit seeking monetary damages against state or its agencies, it says in subsection 3, neither the state nor any of its agencies shall pay or be required to pay monetary damages under the judgment of any court except pursuant to an appropriation made by law. To enforce a judgment for monetary damages against the state or a state agency, the sole remedy of the judgment creditor, here we would be talking about the counties, if there has not otherwise been an appropriation made by law to pay the judgment, is to petition the legislature in accordance with its rules to seek an appropriation to pay the judgment. But as we said here, over and over again, they only talk about two different places. One is using 215.26 to raid other counties' money that they've paid in. This is going to create a $9 million shortfall right now in being able to fund juvenile detention costs. The legislature certainly never provided for this.
Well, your
There's no
time has
appropriation.
expired, counsel.
Oh,
Thank you for
Your
your
Honor.
argument. You can briefly conclude if you like.
I appreciate it, Your Honor. So basically, we've got two different ways that they're trying to get to this. One is through, both of which lead back inexorably to the problem that there's no appropriation. Either they want to raid the trust fund and take counties' money, other counties' money away, robbing Peter to pay Paul, leaving a shortfall of $9 million in current revenue needs for funding these kinds of costs for juvenile detention. Or they want to force DJJ to go and shake the trees itself to find an appropriation, which it does not have. It did not get an appropriation for this fiscal year from the legislature to be able to pay these $9 million. The legislature provided an alternative remedy. They've chosen not to take advantage of it. We invite them to. Thank you, Your Honor.
Thank you, counsel. Thank you both for your arguments.